to court. And that is what the law says. Talking about your constitutional fundamental human right as provided from Section 33, right to life, up to Section 44, talking about a right to own movable properties. That when you suspect, all these people don't know, talking about is inclusive police harassment, police searching without warrant, someone trying to trespass you, someone trying to invade your privacy, it haven't happened, or you suspect that it will happen. The law says that you should go to court. Don't leave it to God, because it is your guaranteed fundamental human right. Now, talking about civil cases, it's not every time you go to court. It's advisable, and lawyers are expected to advise their clients whenever they bring a matter to them that this is it. There are conditions or prerequisites that must be in place before you go to court. Now, one of them is, do you have the local standard? Talking about, does this matter concern you? Do you have any interest in it? I will make an example with this, talking about this Section 84, sub 12 of the Electoral Act, which people have been dragging up and down. Someone that is so overzealous, I think Barrister Nduka went to Federal High Court in Abia State and filed it and got a judgment in his favor. Now, the matter went on appeal. I happen to be the one that filed for appeal. So the matter went on appeal. What the Court of Appeal says, my demand that filed this thing, you don't have the local standard. So that's one of the reasons why that judgment was nullified. So first thing first, people who are always eager, let's sue him, I will report it to my lawyer, let's do this, let's do that. But the lawyer will first of all say, does this matter? Do you have a personal interest? Does it concern you? We call it in law local standard. Now, when you've established that the person have a local standard, like the matter concerns him, then we talk about jurisdiction. What court is competent enough to hear this matter? There are territorial jurisdiction. That means land, like for example, in land matter, they call it lex situs in law. You should institute any matter concerning land in the place, in the location where the land is situated. Let's say you have a land in Abuja and someone commit a breach or trespass. It doesn't matter that you are not from Abuja, you are not indigenous of Abuja. Maybe Kogi is your state, you want to go there and file it. No. High Court in Kogi does not have jurisdiction. It's the place, the FCT High Court here in Abuja, where the land is situated, that have the jurisdiction. These are the things people look at before you approach the court. These are the prerequisites. Now, there is another thing. They talk about monetary jurisdiction is also there. It is the law that when tenancy matter, that when it is the money, the amount is below 10 million, the tenancy for your lease fee, you should approach the magistrate court. But when it's 10 million above, High Court has jurisdiction. Now, there are other things like immunity. Does the person you want to sue, is the person that can be sued in law? Like someone, a sitting governor, you can't sue the person, you can't sue a sitting president, you can't sue a diplomat. These are the things people look at. Why people are rushing to court? You check all these things. Lawyers look at all these things. Then we also look at, does this matter, is this statute bad? Because there is a time limit in law where you have to take a matter to court. If you sit on your right and that time elapses, you are estopped. They call it estoppel, principle of estoppel. You are prohibited to approach the court. And public service, if you want to sue a public servant, a public officer, or maybe a public officer offended you, you have just 3 months. So if you don't do anything within the space of 3 months, in law it's deemed that you've slept on your right and you cannot revive the matter when the time has passed. Now, there are other things. There are ADR. I also am a strong advocate of ADR. It's not everything you go to court for. Because court is always, if you go to court now, court is always flooded with some, they call it frivolous matters. Something that it should be settled amicably. Some lawyers will be scratching, let's go to court because they want to squeeze out some money from the client. But it's easier when you approach ADR. They call it alternative dispute resolution. And before you go to court, before you take a matter to court expects you that the court should be the last resort. So you should present a document that you've, just like the matter I'm currently handling, we've wrote a letter of demand. You can't just go to court without first writing, they call it pre-suit notice. You first write a letter to the person you want to sue, that's so I'm demanding so thing. If you did not do so thing within the time limit so thing, I will not have any other option than to go to court. Now, if you are going to court, we are presenting that document, that pre-suit notice, that course we don't just rush to court because we are excited of coming to court. We also try to settle this thing out of court, but people are not coming, they are not following up, or they don't want to heed to the voice of reason. That's why we approach the court. So they call it even and the court is prohibited most times. The lawyers are prohibited of going to court over everything. Negotiation is there. Have you tried negotiation? Have you tried mediation? Have you tried arbitration? Have you tried other aspect of ADR, alternative dispute